So looking at domestic divorce. So this is the case where Richard and Isabel begin divorce proceedings. Key issues here are grounds on which Malaysia Divorce Court will exercise jurisdiction to grant a divorce, and is Malaysia Divorce Court bound to enforce the terms of a pre- and post-nuptial agreement? So the key one here is, I guess, the basis on which the court will exercise its jurisdiction to grant a divorce. So when we've done this previously, we've looked at different nexuses that the courts will look at in the other jurisdictions that we've sort of canvassed on these virtual round tables, and some of them look at residency, habitual sort of abode. What's the nexus that Labuan, that Malaysia will apply when exercising its divorce jurisdiction?
There's a requirement that both parties must be domiciled in Malaysia. So that's the general requirement. There are exceptions. So for example, if the husband had deserted the wife or been deported from Malaysia, for example, and the wife had been resident in Malaysia for 2 years prior to commencing divorce proceedings, the court would also take jurisdiction in those circumstances.
Right.
And sorry, just to add an interesting thing, because I was talking about domicile, it's also actually provided in Section 3 of the Law Reform Marriage and Divorce Act 1976, that if you're a citizen of Malaysia, then by law, you're deemed to be domiciled in Malaysia until the contrary is proved.
Right. Okay. So that can, that will lead to some interesting variations. I think that there's a similar provision in the Singapore equivalent, where they also deem you to be domiciled by virtue of your citizenship as well. But this can be rebutted, obviously. I think we discussed the nuptial arrangements, and here we're still awaiting a sort of case that decides whether or not what weight the courts will put into nuptial arrangements, whether or not they're just persuasive or they'll follow them to the letter.
I should just follow up as well, Zach, to make it clear that the Law Reform Marriage and Divorce Act only applies to non-Muslims.
Yes, that's right.
Yeah. So you're talking about Muslim marriages, etc. That's not part of our discussion today.
No, correct. That's right. Now, with respect to the trust established in Labuan, there are a couple of questions on this. Can a Malaysia Divorce Court make an order varying the terms of a Labuan trust, and can a Malaysia court set aside the transfer of assets into a Labuan trust? So I suppose the first question is premised on, obviously we've got some of these matrimonial causes acts that have been circulating within Commonwealth jurisdictions, and they provide for what they call sort of nuptial settlements. And within that, the court has discretion to vary nuptial arrangements, nuptial settlements rather. The first question, I guess, is within the Malaysia sort of Matrimonial Causes Act, do we have the concept of a nuptial agreement or a nuptial settlement? And if we do, does it provide for the court having power to vary that in the context of a trust? And then looking at Labuan particularly, because it has very sort of advanced firewall protections around Labuan trusts, whether or not a divorce court in Malaysia would be troubled by any of these sort of protections because it's effectively within the same country or jurisdiction. And then obviously looking at the whether or not any of the transfers into a trust, in this case Labuan Trust, could be set aside if they were done for reasons of trying to frustrate a divorcing spouse. So that's usually the context in which these questions are asked. So I just invite you to comment on both of those.
Yeah, I mean, the main provision that we need to look at is obviously Section 102 of the same act that we've been talking about, the Law Reform Marriage and Divorce Act 1976. And in that section, very clear powers are given to Malaysia Divorce Court, whereby they can set aside disposition of property within 3 preceding years if it can be shown that the object of that disposition was really to reduce the means to pay maintenance or to deprive the spouse of a share of that property. So under those circumstances, a Malaysian divorce court is given power and has the powers under this section of that act to actually set aside that disposition. And before the disposition actually takes place, there is also power under the same provision for an injunction to be given by the Malaysian divorce court. Of course, you need to satisfy the requirements in order for the injunction to be given. And if you do, then the court can actually prevent the intended disposition of property in such a situation. I think when it comes to varying the terms of a Labuan trust, that's slightly different, because that's a lot wider when you're talking about varying the terms. I mean, if it's to do with the disposition, then they can do that. But varying the terms, not sure that the powers of the court go that far actually.
Right. And because if it happens, let's say the disposition was made more than 3 years before the divorce proceedings, then they would be thrown back on whether or not there is power to vary the trust.
I mean, if it's more than 3 years, then I think very clearly there wouldn't be.
Yeah. Okay. All right. And moving on to, would a Malaysian divorce court seek to make an extraterritorial order dividing UK property, and would UK court recognize and enforce a Malaysian court order in those circumstances? So do the Malaysian divorce courts actually habitually make extraterritorial orders as a matter of practice?
I think they could, because I mean, they have jurisdiction over that couple, and in granting a divorce, they have the full powers under the Act. But I think it's more whether in reality, in practical terms, whether there's any effect at all of making such an order, because we are talking about, as you said in your question, an extraterritorial order. So, it's going to be a Malaysian court issuing an order. The question would then be, would the UK courts recognize such an order? And it may not necessarily be so. And in any event, I don't think it will be automatically enforced, because it's not the same as something like a reciprocal enforcement of judgment, which has its own rules. And this is a lot more complicated than that, because it's not a judgment sum. So I think in reality, there would be no force of any such order as such in the UK. So in theory, perhaps, but in practice, I don't think it would actually be carried out. But then, of course, the other way of looking at it is that if the parties are within the jurisdiction of the Malaysian court, then if one of the parties is not abiding by it, and perhaps there's a situation of perhaps holding that party to be in contempt, etc. But not in terms of going directly and having it enforced in the UK.
Yeah, no, I'd agree with that. I mean, the relevant Administration of Justice Act 1920 would be the relevant linkage with the UK, and there it would just effectively apply to a money judgment. So they generally wouldn't get involved in a sort of personam action where it's involving divorcing spouses. So I think you're probably right. As long as, let's say, it's Richard that's trying to do this, remains in the jurisdiction, then I think it will be a direct order against him to transfer the property as in part of settlement of the divorce proceedings, upon pain of sort of contempt of court and prison.